Yes.
My Lord, my ladies, as the court is aware, the club's appeal in this regard raises 3 violations of fundamental rights, which we would submit render recognition of the Spanish judgment, contrary to English public policy. The first is the CLC ground, as I will call it. That is to say that the Spanish judgment was arbitrary or manifestly unreasonable in imposing civil liability in excess of the CLC limit in violation of Article 6 and Article 1, Protocol 1 of the European Convention on Human Rights. Second is the new facts ground. The Supreme Court found the master guilty on appeal by finding new facts, but without hearing directly from him, in violation of his Article 6 rights and by extension, the club's own Article 1, Protocol 1 right to have its civil liability determined without procedural unfairness. And third, as the Human Rights Committee, which is the peak treaty body policing the ICCPR, has now found, the Supreme Court violated Article 14, subparagraph 5 of the ICCPR by convicting the master on appeal without giving him the right to a full review of conviction and sentence. Can I start by saying, in relation to the third of those grounds, I'm not proposing to add anything to what is said in our skeleton. Our skeleton, as the court is aware, has been supplemented by a brief note which I hope the court received electronically last night.
Yeah.
Professor Webb is here to answer any questions in relation to that ground, but will not be here tomorrow, and so I am going to stop come what may at 4 o'clock in order that the court can ask any questions that the court wishes to ask of Professor Webb.
Thank you.
So let me move straight on to the CLC ground, and the first proposition is that there is a fundamental right under both Article 6 and Article 1P1 to be free from an arbitrary or manifestly unreasonable judgment, which, if violated, is a good ground for refusing recognition under Article 34.1 of the regulation. The judge recognised that the right to be free from an arbitrary judgment is a right which is recognised as fundamental in England. That is paragraph 123 of his judgment in relation to the human rights issue. You'll find that at the core bundle, tab 21, page 453, for your note, but I'm not proposing to take the court to that paragraph. However, it's important at this stage for the court to see the nature of the right under the Strasbourg authorities to understand why the judge erred in rejecting this ground of appeal. And I need to start in this context with one of the Article 6 authorities, namely Bochen against Ukraine. That's in Authorities Bundle C, Volume 7, tab 56, page 1982.
Sorry, which one? 1682?
It is Volume 7, tab 56, page 1982. Probably the page reference is the easiest, as long as the page numbers are the same in relation to in the electronic bundle.
But they're not. Anyway, we can find it. Good. Bochen, yes.
Bochen, which is a judgment of the Grand Chamber.
What are we looking at this for?
We're looking at this for the proposition that it is open to the reviewing court to review the judgment of the incoming court, but we're looking at it to see what the nature of the right of review is. Because essentially what the nature of the right of review is to determine whether or not the findings in the judgment are arbitrary or manifestly unreasonable, so as to render the judgment unfair. Looking at the case itself, then if we start at paragraph 21, this was a case of a ping-pong between the domestic courts and the Strasbourg courts. In Bokken number 1, then the European Court had held that certain property proceedings were unfair. Mrs. Bokken took that judgment back to the domestic courts and asked them to quash their earlier judgment. And if we go to paragraph 21, then the European Court sets out the reasons that were given by the domestic courts for rejecting the appeal. You'll see this paragraph 21, as I say, that then the European Court sets out the relevant part of the Supreme Court's decision, which read as follows. And perhaps if I can ask the Court to read down to the end of little d. Then and indeed the relevant passage goes all the way down to the bottom of paragraph 21. Mrs. Bokken said that the domestic court's reading was a misreading of the Strasbourg court's judgment in Bokken number 1, and she went back to Strasbourg, and it was that which led to this judgment in Bokken number 2. If we then move on in the judgment to paragraph 60, the court deals with the merits of this application. And you'll see at paragraph 60, as regards the question of compliance with the requirements of Article 6.1 in the present case, the court observes that the applicant's unfairness complaint was directed specifically against the reasoning the Supreme Court employed in its decision of the 14th of March 2008. It reiterates that according to its long-standing and established case law, it is not for this court to deal with alleged errors of law or fact committed by the national courts, unless and insofar as they may have infringed rights and freedoms protected by the Convention. For instance, where it can exceptionally be said that they are constitutive of unfairness incompatible with Article 6 of the Convention. While this provision guarantees the right to a fair hearing, it does not lay down any rules on the admissibility of evidence or the way in which evidence should be assessed, those being primarily matters for regulation by national law and national courts. Normally issues such as the weight attached to given items of evidence are not for this court to review. The court should not act as a fourth instance and will not therefore question under Article 6.1 the judgment of the national courts, unless their findings can be regarded as arbitrary or manifestly unreasonable. So the important points to take from that are not a court of fourth instance, court won't deal with errors of law or fact unless and insofar as they have infringed rights. And examples of those are where the findings are arbitrary or manifestly unreasonable, such that they are constitutive of unfairness. Then at 62, the court refers to past cases in which it has found that there has been such an error. And it refers to the thinking underlying this notion of erreur manifeste d'appréciation, a concept of French administrative law as used in the context of Article 6.1 of the Convention, and that, they say, says that if the error of law or fact is so evident as to be characterised as a manifest error, that is to say, an error that no reasonable court could ever have made, it may be such as to disturb the fairness of the proceedings. In Kamidov, the unreasonableness of the domestic court's conclusion as to the facts was so striking and palpable on the face that the court held that the proceedings complained of had to be regarded as grossly arbitrary. In Andelkovich, the court found that the arbitrariness of the domestic court's decision, which principally had no basis in domestic law and had not contained any connection between the established facts, the applicable law, and the outcome of the proceedings, amounted to a denial of justice. And then, my lord, my ladies, perhaps if I can then just ask you to read to yourselves paragraphs 63 to 65 of the judgment. So what the court sees is that the European Court here goes through a close analysis of the reasoning of the national court in order to determine whether there has been unfairness within the test as identified in the case, including arbitrariness or manifest unreasonableness, which makes the judgment unfair. An example of the court considering the assessment of the facts and evidence is the Kamidov case, and perhaps if I can ask the court to go to that briefly, that is in tab 46, page 1612. Authorities Bundle C, I'm told, volume 6, tab 46, page 1612. Yep, that's the one. Thank you very much indeed. And in this case, the applicant claimed that his claim for state compensation was dealt with unfairly. And if the court goes, or can be taken to paragraphs 170 to 174, if those could be brought up on the screen. And then if I could just ask the court to read through those paragraphs to itself. that is a case in which the court analyses the evidence and the domestic court's evaluation of the evidence and concludes that they are incoherent and so arbitrary that it means that the applicant did not have a fair hearing. Next, though I'm not going to take the court to this, is the Lazarevich case. That's in Authority Bundle C, tab 61, page 2172. And if I can just give the court the relevant paragraphs to note, they're paragraphs 6, 15 to 18, 28 to 32, and 30 and 31. In particular, 30 and 31, and 30 at the bottom of page 2178, the court once again notes that it is not a court of fourth instance, but it may find a violation if the decision is arbitrary and manifestly unreasonable, resulting in a denial of justice. And they cite in that regard another Grand Chamber decision, namely the Moreira-Ferreira case. And at 31, the European Court engages in a process of evaluating the domestic court's legal reasoning and whether it had correctly applied a domestic statute and domestic case law, and concluded that the ruling was arbitrary and amounted to a denial of justice. Those are just a few examples, but there are others. For example, there is another decision of the Grand Chamber in the Anheuser-Busch case, which is Authorities Bundle C, tab 44, page 1504, and the relevant paragraph is 83. So those are examples of the correct approach from the perspective of the Strasbourg court. And that approach is replicated in the EU regime through, firstly, the EU Charter of Fundamental Rights, which contains rights which are equivalent to Article 1, Protocol 1 and Article 6 of the European Convention on Human Rights. Thus, at page 175 of the bundle is Article 52.3, and that states that insofar as this charter contains rights which correspond to rights guaranteed by the Convention for the Protection of Human Rights and Fundamental Freedoms, the meaning and scope of those rights shall be the same as those laid down by the said Convention. There is also then EU authority which...
Sorry, which? Catching up with the page.
Yep,
which article?
It is Article 52 sub Article 3, my lady. Then there is also CJEU authority confirming that a national court applying the Brussels regulation must comply with the requirements flowing from Article 47, namely the fair trial guarantees, and that is the Moroni case. And again, I'm not going to take the court to it in view of time, but for your note, the reference is Authorities Bundle C, tab 34, and it's in paragraph 28 of the Advocate General's opinion at page 1209 of the bundle, and paragraphs 43 to 45 of the court's judgment. And my bundle's at 1224, but it's probably best for the court to go by reference to the paragraph numbers, given the problems we've been having. The judge, however, rejected the club's reliance on violations of this right in reasons which started at paragraph 121 of his judgment. And in summary, the club's position is as follows. Firstly, there is nothing in the Brussels regime which prohibits the English courts from evaluating the complaints of arbitrariness on their merits. Secondly, the Spanish judgment in relation to CLC liability was arbitrary in reaching conclusions that no rational court could have reached, given the limits of the Supreme Court's powers and the nature of the proceedings before it.
Sorry, you said Spanish courts findings on CLC. You mean non-CLC?
Non-CLC, yes. So yeah, in relation to CLC liability, so the fact that they actually held that the CLC limit did not apply on the facts of this case. Just by way of a taster, my lady, then, the Spanish Supreme Court's proceedings were by nature of cassation proceedings.
Yes.
And so, as your ladyship knows, they effectively have to, they're governed by the facts as found by the first instance court. They then apply the law to those facts. What they can't do is find new facts. And in this case, what they did is exactly that. They found new facts. Had they not found the new facts, then they couldn't have found that there had been willful misconduct so as to lead to a breach of the CLC limits.
I mean, you make it sound terrible, but that's pretty common in civil law countries. Not talking about Spain particularly.
No, and it's not pretty common in relation to this issue. This was so uncommon that it led to a decision of the International Maritime Organization to issue a ruling as to how willful misconduct should be applied, because they said this was a limit that was intended to be and should be virtually unbreakable.
We're talking about the CLC limit.
I'm talking about the CLC limit.
But is that an issue before us?
Yes, it is. Because of the fact that it's only because of the breach of the CLC limit that we then get up to anything like the limits of the insurance policy. It's of importance outside the ambit of the CLC as well, the issue of willful misconduct, because it's exactly the same test under the Convention on Limitation of Liability for Maritime Claims.
So could you just tell me where the club accepted liability within the CLC limit in the Spanish proceedings?
Yes.
How quickly did it do that after the proceedings were initiated?
They didn't. They deposited the relevant fund at the outset of the proceedings.
What do you call the outset on the same? It can't be on the same day.
In May 2003, before the criminal proceedings began.
In May 2003, you
Yes.
deposited the CLC limit.
Yes.
Which was how much?
22 million. 22 million.
Euros.
Sure it's euros or dollars.
I think it's dollars.
I think it was dollars, my lord.
Dollars.
Although I think it will have been expressed in special drawing rights at the time.
So they did that.
They did that.
Of their own motion.
Yes.
Depositing in the Spanish court.
That's right. Because, as I indicated...
So sorry to just to ask.
I'm sorry, my lord.
A few questions. So they deposit the CLC limit, saying this is the limit of our liability as insurers of the vessel. Presumably, in order to get that money out, the fishermen, as you call them, had, and possibly the Spanish state, had to bring proceedings.
No, they still haven't got the money out, principally because of the existence of these proceedings.
No, but that doesn't answer my question. They, in order to get the money out, they can't do it without an order of the court. Can they? I mean, I'm asking. I have no idea.
If we go back to that point, my lord, the jurisdictional provisions of the CLC are that the local court, in this case the Spanish court, has jurisdiction in relation to CLC claims. So it actually is in charge of distributing the CLC monies and indeed the fund convention monies.
Okay, so there was never any dispute about jurisdiction of the Spanish court in relation to the CLC funds and the funds
Right.
amount.
Quite.
What was the fund amount?
The fund amount is about 100 something million, isn't it? 115 million.
And when was that deposited? When was that deposited?
That was deposited, can I just check? When was that deposited? Yes. I'm told I would have to come back to that because apparently it's rather more complicated than the CLC fund itself.
No, but you see why I'm interested is that there seems to be some acknowledgement that the Spanish court has something to do with all this.
Well, in that sense, yes, because as far as the CLC is concerned, the Spanish court does.
And also the fund.
And also, yes, although of course the fund is not the club. The fund is an independent entity. The fund is, fund convention is administered by an independent entity. The monies actually which make up the fund are contributed by oil companies.
So we should probably put, on that basis, put the fund to one side. We're focusing on the club here.
Yes.
So maybe the fund amount is a bit of a red herring.
Probably yes, my lord, my lady.
So that wasn't deposited by the club?
That wasn't
or
deposited
to do
by
with
the club. No.
No, so it doesn't matter. So for this purpose, you came along to the Spanish court and said, hello, there's been an incident with a vessel for which we are offer coverage, and we will now deposit the limit of our coverage under the CLC within the court. Now, that must have involved some kind of correspondence or discussion or what?
I think, my lord, I'd have to check, but I think the position is no, it doesn't involve discussion. What happens is simply that you go and you constitute the fund, because the club is strictly liable under the CLC for the amount of the owner's liability.
Yeah, I know.
So there is a right of direct action against the club under the CLC.
Understand, but what I'm getting at is what Spanish proceedings are necessary. I mean, if you came to the court office here with $22 million and said, can I give it to you, please, because there's been an accident in the English Channel, they would say no, right? They would say no, we need to know, we need to have an action number. I know that. Now, what happened in Spain? Because if the club had to make an application, then that is at least some kind of acknowledgement of some kind of jurisdiction in Spain, right? I know it's only CLC and I know it's all a completely different thing, but I want to know what relationship there is between that deposit and the subsequent claim in 2010. And how you get the money out.
I'm afraid I cannot answer your lordship's question standing on my feet at the moment.
No.
And I will therefore take instructions, if I may,
Would you overnight?
in order to be able to answer your
That
lordship's
would be really,
question.
really helpful.
Yeah.
I mean, I did say on Monday, no, that was Monday last week. When did we start? Tuesday. That I was quite interested in the nature of the obligation said to arise, breach of which gives rise to equitable compensation.
Yes.
And this goes, I think, to that point as well as the one you're on now.
Well, again, this was a point which, from recollection, I'll check as well, was something that was argued in front of the arbitrators.
It was?
Yes. Because what was said was that essentially by, and indeed you'll see in a moment or in a little while, I take you to the Supreme Court judgment, the Supreme Court in Spain relied upon the fact that the CLC fund had been constituted by insurers as being somehow action which precluded the insurers from relying upon their rights under the insurance policy. So they said you went further than you needed to. The arbitrators said, or at least Sir Peter Gross said, I think that's not correct. But I will come back and I'll check in relation to Sir Peter Gross's award precisely what the nature of the argument was that Mr Young took, and I will.
But I mean, I'm interested in that, so please do.
Yes, I will do so.
But I'm not interested in reopening something that's not appealed from Sir Peter.
Yes.
But I am interested in knowing if any insight is given into the nature of the obligation of which you do claim equitable compensation.
Yes. And my immediate answer to that, though I will check it, is no insight is given, because these are two wholly independent regimes. The fact of the matter is that there are CLC.
So what are the two? CLC.
The CLC regime, rights and obligations, the insurance regime, rights and obligations, those are two completely independent regimes.
Surely the CLC right depends upon the coverage under the club's rules.
No.
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 Not at all.
It's strict liability. Up to
Is it the case that the club insured the CLC element and separately gave the insurance that we're having
Yes.
all these arguments
Yes.
about?
It
So,
is.
if you like, two separate.
They are two separate regimes. One is an international regime under which whoever the insurer of the owners is strictly liable pursuant to the statutory obligations or the treaty obligations as incorporated in the various different countries around the world. So that's, if you like, regime one, the CLC regime. Regime two is then the insurance regime. The way it's actually quite often explained is to say that there is a compulsory insurance regime, which is the CLC, and there is a voluntary insurance regime, which is the insurance policy.
But if you had not paid the compulsory insurance voluntarily, sorry to confuse, under the CLC, how would that have been enforced?
By enforcement against the fund. So each
Well,
vessel.
I think you said there was the Spanish courts were given jurisdiction.
That's right.
Under the CLC.
Under the CLC.
So it's a completely separate.
It's a completely
jurisdiction.
separate regime. And there is a regime which is called the blue card regime. And the blue card regime is the compulsory insurance regime, which is the CLC regime. Then, separately, there is voluntary insurance. And that is an obligation owed to the owners by the club under the policy. And it's that voluntary insurance which the states then seek to take advantage of by suing on the insurance, which in turn gives rise to all the arguments about conditional benefit and the like that we have been dealing with.
And that didn't take place until 2010.
That didn't take place until 2010.
I mean, I know it may not matter, but I was still interested in the answer to the question.
Yes.
If club had not paid in the $22 million, how would it have been obtained from the club?
The answer I apprehend, again I'll check it, the answer I apprehend is that they would have been sued pursuant to the CLC regime in Spain, because as I've said, under the CLC, the Spanish courts have jurisdiction because the CLC gives them that jurisdiction. So that's why one shouldn't confuse these two regimes. One is a regime which is statutorily, internationally agreed. In that international agreement, there is a jurisdictional provision which gives jurisdiction to the courts of the place where the harmful event occurred, viz. Spain. Quite independently of that, there is the insurance regime.
The voluntary insurance.
The voluntary insurance regime.
When did all the fishermen can't remember how many you said, thousands, hundreds,
Several hundred.
several hundred fishermen. When did they become parties to the proceedings, and did they sue under the voluntary regime?
They became part of the proceedings, I think, when in 2010. Mr. Thompson rightly says to me, we're getting into deep waters in a sense here. We'll need to check exactly what the actual dates are. My recollection, and it is only recollection, is that there were hundreds of pleadings.
Hundreds of pleadings?
Hundreds of pleadings from the various fishermen. But those, I think, are likely to have been in 2010.
So there's not one document that says Spain, France, and 943 fishermen against the club?
No.
No.
There's lots and lots and lots of pleadings in which the various different claimants make their claims for individual amounts.
I mean, what I find difficult to understand here is that those were criminal proceedings,
yes,
which I understand also amount to civil proceedings, but presumably there must be some criminal indictment that starts it all off, which says you, the master, and the owners have done these bad things, unrelated, well, not unrelated, but certainly not directly related to the claim that you should pay statutory claims under the CLC and under the insurance policy above that because of willful default.
Yes. As I say, yeah, my lord, I think trying to put it simplistically, as it were, you have a set of criminal proceedings which is brought by the criminal plaintiffs. Actually, it's the prosecutor usually who brings the criminal proceedings against the master in this instance. There are then civil proceedings which are heard together with the criminal proceedings as a matter of procedural economy. You have the entirely separate CLC liability regime, which is a statutory regime.
But you say entirely separate, but the voluntary liability is claimed on the basis of breaking the CLC limit on the grounds of willful default, isn't it?
No, I don't believe it is. And we would need to look back at the pleadings themselves. Do you remember I told you that Mr Schaff said that he wouldn't give a declaration in relation to willful misconduct because there wasn't any allegation of willful misconduct in Spain? So, but we will need to look, and much more sensible, I would suggest, my lord, for me to look at this overnight.
Okay, all right, you carry on.
My lord, if it'll help, and it certainly won't, the public prosecutor in Spain brings the prosecution. Those who have suffered criminal injury that have advanced their claim, and the prosecutor then advances their civil claims in the criminal proceedings. I've had that corrected by a Spanish lawyer who behind.
I'm sorry, I couldn't hear it because there's some helicopter going on. Can you say that again?
Yes. The prosecutor, the Spanish prosecutor, brings the criminal proceedings.
Yes.
And the Spanish prosecutor then advances the claims of the individual civil claimants who will be seeking criminal injury compensation. So he advances the claims for civil relief on their behalf, including in this case the Republic of France and the Kingdom of Spain.
So they don't actually do anything at all.
Well, I think they file their losses and then leave it up to the public prosecutor.
So the wrong that is broken, giving rise to all of this litigation, the equitable compensation, is the filing of losses when the criminal prosecutor claims on behalf of those injured. Is it?
As I understand my learned friend's case, I think that's right. But in a sense, he's the one identifying the wrong.
You better tell me.
Yes.
I hope that's another homework question for you.
Another homework question, my Lord. I don't think Mr Young's account is correct, but I think rather than our
let's not argue about
point
it
now, then I should look up and see.
I mean, I'm assuming that in this 50 million pages that we've got in front of us, the answer is to be found.
It is.
Yes.
And there are a number of, for example, arguments that were taken in front of the arbitrators about the relationship between the public prosecutor bringing the claims and the individuals whose claims they were.
Well, that may give us help too.
And, the argument that was taken was that even if Spain didn't bring its claim, and France didn't bring its claim, the public prosecutor would carry on anyway.
I mean, the point I made last Tuesday was in order for there to be equitable compensation, there has at the least to be an obligation of some kind, a breach of that obligation,
yes,
and a remedy for the
yes,
breach of that obligation.
I understand that, my Lord, and that's why I started off when I was dealing with equitable compensation by saying that we know that there was an obligation, because that's been held to be the case. We know that that was a breach, because that's been held to be the case. There is no appeal in relation to either of those questions. The only question that we are concerned with is one of remedy. And so, in a sense, the question of the CLC, which I brought up in the context of the public policy argument because it's relevant to the way in which the Spanish court dealt with the argument, then obviously, in order to answer your Lordship's questions, which go to a separate point, I'll need to find out
yes. I mean,
the answers.
Just so you know, the reason I'm asking is one thing to say there is an obligation and there is a breach. It's another thing to be able to identify the nature of that obligation and the nature of the breach before you come to remedy. And remedies do tend to turn on the nature of the obligation and the nature of the breach,
Yes,
just as a matter of...
Your Lordship has my submissions, because I made them in
I
detail.
have the submission on the nature of the remedy.
On the nature of the remedy. What I'm dealing with now is a separate question, which is the question of public policy relating to the Spanish judgment. This is, in truth, an aspect of the Brussels appeal that we spent the first 3 days dealing with, because this goes back to
dealt with before the Brussels.
This goes back to Article 30. Well, the judgment was given before the remainder of the Brussels point, but
Yes,
actually it was all in front of the judge on the same proceedings.
Yes.
He chose to give judgment on some of the points.
And then he made references.
And then he made references. Well, he made references, then he gave judgment, and then actually got the reference back, and then he gave the second judgment, as your Lordships know. But so, in a sense, where we now are is we're back to what we were discussing on the first 3 days of the appeal.
Sort of.
Well, because we're now back to Article 34.1 of the regulation and the public policy ground of the regulation. And now actually we're dealing with the question of whether or not there has been a breach of Article 34.1 of the regulation by reason of the way in which the Spanish court dealt with the claim.
Exactly.
So, my Lord, my ladies, then I was setting out, as it were, the 5 propositions that I need to address. And the first was that there was nothing in the Brussels regime which prohibits the English courts from evaluating the arbitrariness complaints on their merits.
Yes.
The second was that the Spanish judgment in relation to the CLC liability was arbitrary because it was based upon new findings of fact. The third was these fundamental rights are core values, and where violated, then they constitute public policy grounds to refuse recognition under 34.1. The fourth is that there was nothing further the club ought to have done in Spain to raise the arbitrariness point. And the fifth is the conclusion flowing from the first four. Then the court should set aside the judge's order and refuse recognition on the basis of Article 34.1, or if there's any doubt about the matter, then the court should remit matters to the judge, for the judge to evaluate these matters on a proper basis, because for the reasons I'm just about to come on to, he didn't do so. In fact, if the court is of the view that this appeal is not already going to be disposed of by reason of the arguments that we dealt with over the first 3 days of this hearing. Because obviously, if the court is with the club on those issues, then this is effectively by way of obiter dicta on the part of the judge. Had he dealt with it all in one judgment, then one might imagine that he might well have said, well, I never need to get to the public policy on human rights grounds because of the fact that I've already found in favour of the club on the other grounds. So the first question is the correct approach to an arbitrary judgment argument in the Brussels context. The judge relied on Article 36 of the regulation, and that article provides that under no circumstances may a foreign judgment be reviewed as to its substance. That's at paragraph 124 of his judgment, where he continued to say that the court of the member state in which recognition is sought may not review the accuracy of the findings of law or fact made by the court of the member of state of origin. That's my emphasis, that's the judge's emphasis.
That comes from Moroni.
Well, he says it does, but it actually doesn't. Because Moroni says that there can be a review where actually the findings of the court who gave the incoming judgment was so arbitrary as to be unfair within the meaning of the Strasbourg authorities that I've just taken the court to. Moroni says nothing different from that. Indeed, in one of life's little ironies, what Moroni actually relied upon is the passage in Krombach against Bambursky that the court is familiar with in the context of Article 34.1 and public policy and arbitration. But so what the judge said is, he said that the approach does not mean that there can never be cases which are unenforceable because manifestly unreasonable or arbitrary, correct? There might be cases, for example, where there is no attempt at legal reasoning or the result is manifestly made to depend on a matter which has nothing to do with a view of the relevant law or facts. But if there is a process of fact-finding and legal analysis, then the Moroni approach dictates that the enforcing court should not examine them to see whether they are right. So effectively, the judge says, you don't bother to ask yourself whether the incoming judgment is unreasonable so as to be unfair, because you're not allowed to investigate that at all. And with great respect, that's wrong. Firstly, dealing with matters as a matter of principle, there is simply no meaningful basis for the distinction that the judge identified between a case in which the foreign court doesn't attempt to analyse the facts at all, or its reasoning is manifestly made to depend on a matter which has nothing to do with a view of the relevant law or facts. For example, the foreign court may say, I find in favour of the defendant because the claimant has got red hair. And
But I mean, what he actually said, if I can summarise, was that there might be cases where the decision was manifestly unreasonable or arbitrary. If, for example, there was no attempt at legal reasoning,
Yes.
or the result was manifestly made to depend on a matter which had nothing to do with a view of the relevant law or facts. But he said, if there is a process of fact-finding and legal analysis, then the Moroni approach dictates that the enforcing court should not examine them to see whether they're right.
and my point,
You
my
say
lord, is
all that's wrong.
yes.
The whole
Because
lot's wrong.
Yes.
That reason.
Well,
Okay.
yes, because the authorities that I've just shown the court, the Bokan case, the Kamidov case, and the like, are all cases in which the court did examine the reasoning of the incoming court. They did examine the fact-finding exercise on the incoming court. They reviewed it in order to decide whether or not the decision was manifestly unreasonable. What they didn't do is to say, well, I'm not going to even bother to look to see actually whether what has been found by this court is unreasonable. I'm not allowed to actually go behind the process of reasoning by actually asking myself, have they got it so wrong that that renders the hearing unfair? That's what the Strasbourg.
Should we not look at Moroni then? Because
Yes, we could look at Moroni.
I thought he was simply quoting from Moroni at that paragraph.
Well, that's what he's purporting to do. But if we look at Moroni, then Moroni effectively just cites the Crombatch case, which the court has seen before, as I've indicated. And so if we go to Moroni, and that
Page
is
1210. And it's paragraphs 38 to 41.
So if we go to Moroni, that is in tab 34.
I think my lord's ahead of you, Mr Hancock.
It's paid in the written documents. It's 1, 2, 2, 3. I'm not sure what the number is in the electronic documents.
1230.
I'm very grateful, my lord. And so if we go to Moroni, then the Moroni repeats the Crombach test, as I've indicated. And Crombach made clear that fundamental human rights, especially fair trial rights, form the cornerstone of what may constitute public policy within the meaning of Article 34. If we then go from Crombach forward to the Diageo case, to which the court has been referred in the past as well, then in the Diageo case, which is Authorities Bundle C, Volume 4, Tab 33, then this was a case in which, on somewhat complicated facts, the short point was that the defendant to the judgment had sought to argue that recognition should be refused because the court of origin had made an error of EU law, and that meant that recognition would be contrary to public policy. We then go to page 1172 in the Advocate General's opinion.
Paragraph.
It is paragraph 1.
1.
Paragraph 1. And the Advocate General says there, the key question is whether the fact that a judgment given in the state of origin is contrary to European Union law justifies that judgment not being recognised in the state in which recognition is sought, on the grounds that it infringes public policy in that member state. This case offers the court the opportunity of refining the criteria to be taken into account by the court of the state in which recognition is sought, criteria most recently formulated in the judgment in Orams against Apostolides, with a view to assessing whether there is a manifest breach of its public policy when that breach stems from the infringement of rules of European Union law. Then if we go to paragraph 37, then in the judgment this is, it should be borne in mind that pursuant to the second paragraph of Article 252 FEU, it is the duty of the Advocate General acting with complete impartiality to make an open court reasoned submissions. I'm sorry, I'm on the wrong page.
I think we've got it. Judgment 37.
Trying to go to the next paragraph, just to say paragraphs 37 and 38. Yeah.
Is it the AG one?
Yes,
Then it's
37 and 38 of the Advocate General's speech.
Was exactly the same as Moreni. Just repeats Moreni. Moreni's repeated comment. Yeah. They all say the same thing. You say the judge got that completely wrong.
No, what I'm saying is that these cases say actually that you can review the judgment of the incoming court, but the limits of that review are that you can't simply say the incoming court got it wrong. What you can say is they got it so wrong that that rendered the process unfair. That's what all of those Strasbourg authorities say. They say it's not a court of fourth instance, it's not an appeal court, but what the court can do is to say, well, you've got things so wrong that that actually renders your judgment unfair, which in turn means that there has been a breach of public policy, which means that we don't have to recognise your judgment. Now, if you are not allowed to look at the judgment at all, how is it that you're going to draw any conclusion, draw the conclusion or find that the judgment is so wrong that it offends public policy? Can't be right that you simply cannot look at the judgment at all. The point is
what he said. He doesn't say you can't look at it at all. He said, I think he said, I'll just check, I think he said, enforcing court should not examine them to see if the court is right. Process of fact-finding and legal analysis. Can't go into that.
Is your lordship referring to the to Mr Justice Butcher's?
Yes.
Yes.
This is an appeal from Mr Justice Butcher.
Yes, my point is he got it wrong.
Well, what I'm encouraging you to do is to tell me, in the paragraphs of his judgment that you're criticising,
Yes.
you know, you need to get your screwdriver in, as I normally say in these cases, to show that he was getting it wrong. And he at 124
Yes.
sets out what he says he's applying. He's set out paragraph 41. May not review the accuracy of findings of law or fact made by the court of the member state of origin. That approach does not mean there can never be cases which are unenforceable because manifestly unreasonable or arbitrary. So that's correct, isn't it? There might be cases where there's no attempt at legal reasoning, but if there's a process of fact-finding and analysis, then the Moroni approach dictates that the enforcing court should not examine them to see whether they're right. Now, isn't that correct?
No, it's not correct, my lord.
What's wrong with it?
Well, because of the fact that the Moroni approach, which simply replicates the approach taken in other cases, is that you do look at the reasoning of the court of the incoming judgment, and you do actually, you don't simply say, oh well, there's some reasoning. I'm not going to bother actually asking myself, is that reasoning right, wrong, or indifferent? What you should be doing is you should be looking at that reasoning and saying, is it so wrong that it renders the judgment unfair? It's the standard which has to be obtained. Now, the judge effectively said, I can't look at it at all. Unless there is no process of reasoning, he said, well, then the judgment is out of bounds. I can't look at a judgment which purports to have a process of reasoning in order to ask myself whether that process of reasoning is not only wrong, but so wrong that it goes out with the bounds of reasonableness. As I've made clear from the Strasbourg authorities say you should look at a judgment in order to work out whether or not the judgment is so wrong that it falls out with the bounds of reasonableness. The judge is saying, as long as there's some process of reasoning, doesn't matter how bad that process of reasoning is, I'm bound by it. So, as a result, what he doesn't do, and what you won't, the court won't see, is he doesn't examine the process of reasoning of the Spanish Supreme Court. He simply abrogates that question completely on the basis that the Spanish Supreme Court did have some reasoning. What he doesn't ask himself is, was that reasoning so lacking that it rendered the judgment unfair? That's the acid test that he should have applied. He didn't apply that. He simply effectively said, if there's any sort of attempt at reasoning, I am unable to review that attempt at reasoning in order to determine whether or not it is right or wrong, and how right or wrong it is. But that's simply not right. And again, it's not just me that says this, my lord. All of the textbooks say the same thing. In order to determine whether or not there has been a breach of public policy by reason of the unfairness of a judgment, such unfairness lying in a complete failure to adequately reason, or a complete failure to adequately fact find. In order to be able to do that, you have to look at the judgment, and you have then to test whether there has been an appropriate set of reasons given by the judge in the incoming judgment. You've got to test whether the evidence is relied upon by the court of the incoming judgment was actually sufficient to justify its conclusions. Those are, as I say, the Strasbourg authorities we looked at, Bocan.
Do you effectively say Article 36 got nothing to say? Because obviously the Strasbourg authorities are not, they don't have to consider Article 36. No. I think your submission is that Article 36 really doesn't restrict the power of the court
No,
at all.
no, I don't say that, my lady. The way that the Strasbourg authorities look at it is to say that you cannot review the judgment solely on the basis that there has been an error of law. It's not good enough simply to say it's wrong. It's got to go further than that. It's got to be so wrong that it is contrary to public policy because it's unfair.
Okay, so you say they're in line.
Yes. And that's why I say the textbooks are in line with this as well, because the textbooks say, and well, the references are all in our skeleton, but the textbooks say you have to be able to look at the judgment. You have to be able to review the judgment in order to determine whether or not the preconditions for enforcement in Article 34 are met. And we say, well, the judge just didn't do that. He effectively stopped at a logically anterior stage and said, I can't review the judgment because Article 36 says I can't. What he should have done is to say, well, I can review the judgment, but when I do, then it's not going to be good enough for me to say, even if I think so, that the judge in the foreign court has got it wrong. I have to say that they've got it so wrong that that amounts to a denial of justice, so as to make the enforcement of that judgment in breach of public policy, because one would be essentially the word I'm looking for.
No, I understand.
Yeah, not prolonging, but one would be giving effect to a judgment which in itself was the result of an unfair procedure, the unfair procedure being in the failure to adequately reason or look at the evidence, etc. And in this case, as your ladyship knows, we say that the unfair procedure lay in the way in which the Supreme Court in Spain went about finding facts which were not open to it to find, because of the fact that on an appeal of this nature in Spain, the only thing that the Supreme Court is able to do is to apply the law to the facts as found by the underlying court.
I mean, what the judge actually did was to cite one sentence from Moroni, saying the court of the member state in which recognition is sought may not review the accuracy of the findings of law or fact made by the court of the member state of origin. That's a direct quote from Moroni. He sets it out in lines 4 and 5 of 124, and then he says, applying that approach, it's clear that the club's criticisms of the Spanish judgments are indeed invitations to review the accuracy of the Supreme Court's findings of law and fact, and he then gives 4 sub-paragraphs explaining why.
Yes.
Now, you've got to go further than saying he declined to review the judgment, because he did review the judgment. You have to say, it seems to me, that any of those 4 complaints you made, 1, 2, 3, and 4, that he said were reviews of the findings of fact and law, were not, that wasn't what was required. What was required was to look at those findings and say they are arbitrary, manifest rubbish, they had nothing to do with the law or the facts, they're just prejudice, they're just whatever. There was no finding of fact or law, it's just, to put it bluntly, garbage. And that's what you have to say, and I was assuming that was what you were going to say.
Well, it is, but I had to set the scene, my lord.
Okay.
Which is to start off with the test that the cases have laid down.
Yes, but the test is the one the judge sets out.
Stan rightly says to me that the if we go to the judge's judgment, that particular paragraph that your lordship has in mind,
124.
as your lordship says, it's the 4 sub-paragraphs that in which he makes findings. And my start point is that it's not so much that I need to say that his findings are wrong, barking, whatever.
No.
What
you
I need
had to show that the Spanish court's findings were barking.
Well,
That expression.
no, what I need to show is that the Spanish court's findings were unfair.
And well, they were
Unfair.
so wrong that they were unfair.
Well, A, so wrong that they were unfair, but B, also procedurally unfair. Because
Well, procedural unfairness is a different point from the one we're on here. We're looking at facts and law. The Spanish court's findings of fact and law. And for that, you don't review their accuracy unless you can show that it was manifestly, I've forgotten the words,
What we would say is perverse.
Unreasonable or arbitrary.
unreasonable, perverse.
yes, it is essentially the Wednesbury test, as we would understand it in this country.
Wednesbury.
And we do say that you therefore have to. My first point is you do say that in order to answer that question, that's to say,
Yeah, we've got that. Yeah.
yeah, you have to look at the judgment. That's to say, you have to look at the Spanish Supreme Court judgment. Because you can't actually say, I've concluded that there was no unfairness and that the findings of the Spanish court were not so unfair as to be, so manifestly wrong as to be unfair, without looking at the judgment of the Spanish court. So that's my first point. Whereas the judge did not look at the judgment of the Spanish court. He essentially started off by saying that he couldn't review the judgment at all because of the provisions of Article 36. And my point is that that is not right. He can review the judgment. It would not be enough for the club to say the Spanish court has got it wrong, because the Strasbourg authorities and the EU authorities make it clear that it's not good enough for the club to say that solely that the court has got it wrong. The club has got to be able to go further than that and say that the error on the part of the foreign court is so egregious that it amounts to a breach of public policy. So it is a sort of step change, if you like, from simply saying that the court got it wrong to saying that the court got it so wrong that it renders the decision unfair and enforcement of that decision unjust, contrary to public policy. So going back to the particular paragraph of the judgment that I think your lordship has in mind. I'll get my copy of the judgment out of my files. Then his first reason, at 122, is where he says the club's complaints are an attempt to invite the court to review the substance of the decision of the Spanish court, which is impermissible under Article 36, and the court has my answer to that. That's to say, it's not impermissible, full stop. It's permissible for the purposes of answering the question, is this judgment so wrong that it is unfair?
I mean, the article itself does say, under no circumstances may a foreign judgment be reviewed as to its substance.
Yes, and I would suggest that the words as to its substance are, in a sense, the key to that, because what is then actually, attention is then being directed to the substantive decision in the judgment, as opposed to the procedural fairness of the judgment, which includes the question of whether or not the reasoning in the judgment is so obviously wrong, or the consideration of the evidence is so obviously wrong as to render that judgment unfair. Otherwise, the position would be that you could never look at a judgment of another court within the CJEU in order to work out whether that judgment was contrary to public policy under Article 34.1. And again, the Diageo case indicates that you can look at decisions of other member states in order to review the correctness of those decisions, as long as you stay within the bounds I've indicated, and you review the correctness of those decisions in order to determine whether they fall out with the bounds of reasonableness. So again, I go back to my point that in order to answer the question under Article 34.1, you've got to be able to look at the judgment to work out whether it's not whether it's right or wrong, but whether it's so wrong that it is unfair and contrary to public policy. And if it's so wrong and contrary to public policy, then Article 34.1 says you shall not enforce it. Now, you couldn't even commence that inquiry under Article 34.1 if you weren't allowed to look at the judgment which was being sought to be enforced.
I mean, he doesn't say he wasn't looking at the judgment. He says he wasn't reviewing the accuracy of the findings of law or fact.
So I didn't catch your lordship's...
He did not say that he wasn't looking at the judgment. He said, I'm not reviewing the accuracy of the findings of law or fact. Which is precisely what Moroni said he shouldn't do.
My lord,
I mean, you may be right that he got it all wrong, but you need to tell us why, when he comes to the detail.
Well, can I take it, in a sense, backwards? If you ask yourself, well, what is it that Moroni says? Yeah. What Moroni says is it quotes the Crombatch case. And we've looked at the Crombatch case. Moroni doesn't tell you anything different from the Crombatch case. What the Crombatch case tells you is if there is a breach of a fundamental rule of public policy, then that comes within Article 34.1, and it means you shall not enforce the judgment. And Moroni doesn't take us any further than that proposition. If the judge actually was saying that Moroni does take us further than that proposition, he was wrong for that reason, because Moroni doesn't actually take you any further than Crombatch. Moroni simply actually applies Crombatch. Conversely, in relation to errors of law, and as I've indicated, then in the Diageo case, then the Court of Recognition is allowed to take a view of the foreign court's error of substantive law in relying on the public policy ground. So that clearly does show that there can be a review of the foreign court's judgment.
The impression we've been going around the houses on this point.
I think we
for
probably
20
have.
minutes.
We probably
You
haven't.
haven't really said anything new in the last 5 or 10.
Well, I hope that I've made my position clear, which is
Abundantly.
Proposition 1, then you are allowed to review the incoming judgment, but you're only allowed to review the incoming judgment for the purposes of determining whether or not it falls foul of principles of fairness and therefore public policy. Proposition 2, and just so your lordship and ladyships have the relevant references, then in our skeleton core tab 17 page 350 we set out the references to the textbooks which make the point.
Which
unanimous.
paragraph?
In the skeleton, my lord.
Yeah.
It is paragraph 12.4 of our skeleton. Core bundle, tab 17.
Yeah.
Page 350, though, once again, that may well be or may well not work in the electronic bundles. For my apologies.
Got it. Thank you.
So all of those authorities make clear, all of those textbooks make clear that Article 36 cannot preclude the court from performing the necessary inquiries to determine whether there has been a violation of public policy. But then actually, if one asks, well, did the judge do that? The answer is that the judge recorded some conclusions, but what the judge didn't do is to look at or consider any of the expert evidence of which there was a significant amount in the case, didn't consider the cross-examination, didn't consider legal submission. He simply said that I reject the arguments because they involve criticising the accuracy of findings of law or fact. And we would say that is an incorrect approach because the correct approach is the one I've indicated. You have to look at the judgment to work out whether or not there was unfairness, breach of public policy, which takes me on then to the Spanish judgments in order to, as a whistle-stop tour through the Spanish judgments, to show the court what the findings were at first instance and in the Supreme Court, and why the findings in the Supreme Court were different and new as compared with the findings in the Spanish first instance decision in the provincial court of La Coruña. The provincial court's decision is to be found in the supplementary bundle. I'm looking at in the full supplementary bundle, and it is, my page reference is 1588, but again,
Tab,
Lord, my
please.
ladyships may be different.
I like the title, Most Illustrious President.
So my start point, my lord, is that it is important to bear in mind when we get to the Supreme Court decision what the nature of that appeal was. And the nature of that appeal was that it was a cassation appeal under Article 849.1 of the Spanish Criminal Procedure Act, There are two grounds for lodging an appeal in cassation. The first is Article 849.1, which is an error of law, and that was the type of appeal this was. The wording of 849.1 states that given the facts declared to be proven in the decisions, a legal rule has been infringed. So the appeal proceeds on the basis of the facts declared to be proven. The court reviews questions of law only. That was confirmed by the expert evidence below. Just again for the court's reference, then it's footnote 9 of our skeleton argument. And Mr. Urenia, who was our expert below, noted at paragraph 41b of his report the argument that the court made new findings of fact and then said, one must take into account that in criminal proceedings, the pursuit and advancement of the civil claim is strictly dependent on the existence and finding of a fact constitutive of an offence, which is also the damaging fact. For this reason, the criminal court, and in effect the Supreme Court when deciding a criminal cassation appeal in a civil claim derived from the offence, is also made, will necessarily see its decision on the civil claim conditioned by the factual limits of the subjective and objective elements of the criminal fact. Therefore, in our case, all that is said with regard to the limits of the Supreme Court to determine the relevant facts in respect of both the subjective and objective elements of the crime also necessarily condition the result of its decision on the compensation due by the shipowner on a subsidiary basis. So there was clear expert evidence before the judge that the same limits that applied in relation to criminal liability must of necessity apply to the civil liability part of the analysis. That's also what the Supreme Court itself said about the limits of its power. You'll find that at pages 29 to 32 and 39 of the Supreme Court's judgment. I won't take the court to that in view of time. At pages 1 to 8 and following, the court considers civil liability. At at page 128, the court says that all of the appeals are brought under 849.1 of the Criminal Procedure Code. Then at 137, dealing with legal ground 77, then the court says, having considered the grounds for appeal in terms of violation of the law, we have to address the question from the point of view of the facts declared proved in the impugned judgment and the statements of a factual character included in the legal grounds. So the Supreme Court was saying there that it is applying the same approach as is made clear by the terms of Article 849.1. You review questions of law, but only on the basis of the facts as proven in the lower court. And we would submit that the Supreme Court's decision as to causation was clearly arbitrary on that basis, because the provincial court had held that although the master was guilty of the crime of disobedience, it had also held that that breach did not cause the loss. I'm going to try and deal with the provincial court judgment rapidly. But can I just give you the core propositions in relation to what the provincial court said?
Is it a 400-page judgment?
Yes. Yes, it's about half that size because of the fact there's a translation as well as the
Oh, I see.
the Spanish. So the first point was that the provincial court held that nobody knew the exact cause of the accident. They said that there was a structural failure due to deficient maintenance, but nobody could prove where the failure happened or why. The second point, and this is page 135 of the judgment, was
So
that...
the pages you're using are internal.
They're the internal, my lady, yes. When the incident started, the vessel heeled due to a structural failing resulting in a wide opening in the hull. You go on to say the structural failure was due to a deficient maintenance and conservation unnoticed by and hidden from the people who crewed the vessel as commander or playing any other role. Page 145 and 146, what was said was nobody knows exactly what was the cause of the accident. At 147, then what was said was that in spite of having listened to many technical opinions and having opposed many expert reports, almost everyone admitted that they could not figure out the exact causes of the failure. At page 148, then what was said was by all means nobody can deny the structural failure, but nobody could prove either where it happened or for what reason. And similar findings are made at pages 166 and 167 at the second paragraph of 166 and the bottom paragraph of 167. So those are the first findings. The second finding is that the master did not and could not have had knowledge of the deficient maintenance because it was not visible, and indeed recent documentation showed that it was in good condition. The reference to recent documentation being a reference to the fact that the vessel had recently been certified by class who had given her all of her safety certificates. The third finding was that in fact, including the crew and owners, nobody could be aware of the existence of as serious deficiencies as to produce an imminent wreck. Fourthly, the only persons who could have predicted the deficient condition of the ship were the Classification Society, ABS, and that would have depended upon complex technical analyses and could not have been observed through direct visual inspection. We've seen page 135 already. At page 149, then if I can just ask the court in the fullness of time to read 149 from everything suggests that to the phrase predictable only to the people in charge of checking out intensely, diligently and at full length the structures, which is a reference to class. At page 151, then it is said that the vessel's conditions did not allow to deduce that its structure was so seriously damaged as to advise against navigation. That fact could only have been known through analysis and specialised and comprehensive verification controls, i.e. through mandatory inspections by ABS, the Classification Society. At the bottom of 152, the inspections were made and the vessel certified. The structural failure was due to maintenance deficiencies, but these deficiencies could not have been directly observed, but depended on complex technical analyses. Another reference to class. Page 165, the court's conclusions after evaluating the evidence. The bottom paragraph of 165. The lack of maintenance could not be noticed by the accused or evaluated as serious since it was not visible, and the fairly recent documents of the vessel said that it was in good condition. The bottom of 170. This way, the accusation is reduced to the fact that they were imprudent when they took the risk to navigate on board an unsafe ship headed to be sunk, but it seems impossible to uphold this accusation because nobody has proved that they knew the real condition of the vessel in regard to the maintenance deficiencies which caused it to be sunk. And then at the next paragraph, everybody knew that the vessel was not new and its maintenance condition was as expected from a long period of time amid such a stressful activity. But nobody could be aware of the existence of as serious deficiencies as to produce an imminent wreck. Nobody. The same finding is then made for your note at pages 173 to 4 and the bottom of 194. So that's finding number 4. Finding number 5 is a finding that certain things were not causative of the casualty, those being a failure of the automatic steering control and certain problems with the heating coils. Finding number 6 was that the master was not negligent, still less seriously negligent. The court will have to read all of pages 168 to 174. The bottom of 169 is important. Prestige sailed slowly but apparently safely, maybe with some draft defects that have not been considered as one of the efficient causes of what happened. To navigate in these conditions does not seem any kind of imprudence. 172, nobody has proved that there was any negligence other potentially than on the part of ABS. And then at 173, last line, it has not been proved that the accused wanted to sink the vessel, nor that they knew its structural deficiencies, nor their causes connected to maintenance and or repairs. They just assumed a risky navigation under terms that cannot be considered negligent.
Is they both the master and the owners?
Yes. Well, one could only take it at that, my lady, because
They're both accused.
yes, I mean they're considering essentially the master. They're not differentiating between the master and anybody else.
Yeah.
Probably the references to the master and the rest of the crew. They make no findings at all in relation to the owners.
I see.
Then finding number 7, the master was guilty of the spill of disobedience, but this did not cause the damage and the loss. The civil liability is at page 217. It is deducted from the literal words of Article 109, 110 and 116 that it is mandatory that the damages and losses are the consequences of the felony and misdemeanour. So if the only felony proven is disobedience, quote, it cannot be said that this disobedience has caused the damage and losses of the Prestige oil spill. So those being the facts declared to be proven by the provincial court within the meaning of 849.1 of the criminal code, there was, we would submit, only one rational conclusion that could be drawn, which was that it was impossible to find that the damage resulted from the master's negligence, because there wasn't any, and still more impossible to find that the damage resulted from the master's personal act or omission, so as to mean that the master would lose the benefit of the limit under the Civil Liability Convention. As the court may have picked up, the scheme of the Civil Liability Convention is to render the owners strictly liable. Then liability is channeled away from the master and the crew to the owners, by which I mean that the master and the crew are not to be liable. The owners are strictly liable, master and crew not liable, unless the damage resulted from their personal act or omission committed intentionally and or recklessly with damage that would probably result. And so the first point is the causation point. The provincial court concluded that the master's conduct did not cause the loss. The Supreme Court reached the opposite view, and they did so by reason of finding facts which had not been found by the provincial court. And again, I'll try and go through this as rapidly as possible. At page 53 internally, then the court says that it's considering.
Reference, please.
Sorry, page 53 internally.
Yes, but in what document? We're going from one court to another now.
Yes, it's the Supreme Court's decision, my lady.
Thank you.
Tab 19 in the core supplementary bundle, my lady. I'm using the internal pagination simply because of the fact
Yes.
that I've been looking at it in the supplementary.
Sorry, page please.
The internal pagination is 53.
Yeah, thank you.
Then between 55 and 65, then the court considers the legal requirements for the offence. And the point to note here is that it's actually not a constituent part of the offence to prove causation, because the offence is one of increasing risk. But what the Supreme Court says is that if in fact you have caused the loss, that may be supportive of the finding that you have increased the risk because the risk has eventuated. At 65, legal ground 22, the court begins to apply the law to the facts. 66 to 73, first two elements of the crime are dealt with. And then actually at 76, the court begins by recounting the provincial court's factual conclusion that the cause of the damage was unknown. It says that the lower court analysed certain factual elements which it rejected as being not relevant or not sufficient to attribute negligent behaviour. It then refers to the fact that the appellants, in this instance then the Spanish state, were challenging the inference. From page 77, then the court considers various of the alleged defects, and at page 84, the court draws the various strings together, concluding that the master did increase the risk, which led to a breach of the duty of care incumbent on him. The court says he contributed to aggravating the consequences of the spill, caused in the first instance by the structural fault of the ship, in that he hampered the possibility of recovering the ship and leading it to near the coast while fuel oil was discharging intensely. The behaviour of the accused was a mixture of action in some ways and omission in others. One way or another, he contributed to aggravating the result of the polluting spill and increased the possibility of causing serious harm to the balance of the ecosystem. Those we would submit are clearly factual findings in the context of criminal liability that the master's conduct was causative.
Sorry, what page are you on?
That's page 86.
Sorry.
my lady. So, in clear contradistinction to the decision of the provincial court said no causation on, as between the master's conduct and the loss. This is the Supreme Court saying that there was causation.
What I find so uncomfortable about this is the thought that the Spanish Supreme Court or the Spanish Court of Appeal might be reviewing a decision of our Supreme Court in this level of detail with the level of understanding that we have here, sitting here, of Spanish procedure and process, and a translation which is not written even in English. So I can't understand 1 in every 10 words used in this translation when I try to read it. And you're telling me it's also absolutely clear that there was this massive unfairness, that I have to effectively do something that would be the grossest breach of international comity, in my opinion. Say the Spanish court took leave of its senses. And, you know, it's extremely uncomfortable, Mr. Hancock, for me sitting here as Master of the Rolls in this jurisdiction to even be invited to undertake this incredible exercise, let alone at breakneck speed, without being invited to read the entirety of the thousands of documents the Spanish court had in front of it. I mean, what do you say about that? It just seems to me impossible.
Well, I say two things, my lord. I do say three things. Firstly, I understand your lordship's position.
Discomfort.
I understand your lordship's discomfort in essentially being asked to review a fellow court's decision in the circumstances that your lordship has outlined. I understand that, of course. Two other points. One is that it's incumbent on me, on behalf of my clients, to ensure that they do not suffer as the result of what we would submit was actually a breach on the part of the Spanish Supreme Court of its duties of fairness. So that's the first point, my lord. The second point is, obviously, if the position is that your lordship took the view that this court could not, in fact, fairly determine this question, it would have to be remitted to Mr Justice Butcher. For him, in the light of fuller argument, he has heard full argument already, including...
How long was the argument?
Well, the evidence was 7 days. The evidence was 5 days, my lord. Most of which was expert evidence, some of which was factual evidence. He had written argument. He didn't have oral argument at all because of the fact that he made the reference at the end of the hearing in December, because that had to be done in a hurry because of the fact that we were coming up to the withdrawal date.
I'm sorry, my lord. I remember very positively making oral submissions to the learned judge. They may have been short, by my standards, but perhaps not. But we did make oral submissions.
My lord, we didn't make oral submissions at all in relation to these matters. No, we didn't. We put in post-hearing written notes to the judge.
Were you both there?
Yeah.
Yeah.
So
I remember referring to Smith and Huertas very positively. Orally.
Anyway, we're not going to decide, as a matter of fact, whether you made oral submissions.
no. So my lord, as I say, I do understand your lordship's concerns about this.
Yeah.
I particularly understand that my going through this at breakneck speed, given the timing of the matter.
But I think if you could go through it incredibly slowly, and I wouldn't be any less discomfort.
Now, I understand that, my lord, but it doesn't improve the position as far as your lordship is concerned, because I'm having to go.
I mean, the reality is we've got your skeleton. We see the points you make, and we realise that these are points that have found favour elsewhere, if not with the judge. And so I suppose you're submitting quite reasonably that we should not do anything that disadvantages your client because of a failure of process. So we have to do the best we can with the material you've put before us.
Yes.
And that's what you're trying to do now, is
That
to
is what
draw
I'm trying
out
to
the most
do
major
now.
points for us.
And if it is of more assistance, then obviously what we can do is simply to give you the references to the relevant the paragraphs of the
Oh,
judgment.
luckily we've got the transcript
And-
of what you're saying,
Yes.
as well as the skeleton. I've been trying to follow it in the skeleton, but it's not quite as, doesn't seem to be in quite the same order or in quite the same detail.
No, it's certainly not in the same detail as I've been making submissions to your lordship and your ladyship.
Okay, well, you carry on. I'm sorry.
So, my lord, we looked at causation. That's, if you like, the first question. There are further findings within the Supreme judgment which also amount to findings that there was a causative link between the conduct of the master and the loss. And perhaps the easiest thing there is if we simply send you a note to tell you where within the judgment you'll find those. And that those circumstances, the position is that in relation to causation, the simple position is that the provincial court held no causation, the Supreme Court held causation, prohibition on the
What's missing
Supreme...
from all of this analysis, Mr Hancock, is the fact, which seems to me to be fairly germane to this debate, that the Spanish Supreme Court, when one looks at the earlier parts of its judgment, was being asked to review the lower court on the basis that its decision was perverse and contrary to the evidence and unfair and irrational, and actually so addressed itself. For example, if one looks at internal page 39, a mere discrepancy in the evaluation does not suffice. It must be absolutely irrational or absurd, and it is from this perspective that the appeals filed with relation to the judgment must be approached. So we've got the higher court in Spain saying that the lower court's judgment is irrational or absurd, and you're asking us to find that that decision is irrational or absurd.
I'm saying, my lady, that Spanish law says that you are only, that the Supreme Court has to approach an appeal on the basis of the facts as found by the court below.
Unless it finds those facts were reached wrongly.
That's not what the section says.
Well, that's how the court has addressed itself, and I don't see how we can untie that particular Gordian knot. Just reading the judgment.
My lady, I'm being reminded that the portion that your ladyship is referring to is an appeal under a different section of the Spanish Criminal Code, not Article 849.1, which is the section I'm addressing the court on, which is the section which says that the higher court can only address the issues on the basis of the facts as
Well,
found.
then we need to know how the two fit together, don't we?
I need to check my lady, because I'm being told, and I'll need to check this, that essentially the portion that you just pointed out to me is not part of the relevant part of the appeal for the purposes of the point that we are dealing with this in this court.
But I need to know why, because
yeah, no, I understand.
I don't understand at the moment. I can well understand how you've got a rule that says the supervising court is bound by the fact findings of the court below. I understand that.
Yes.
But if you put that into a context where the supervising court is also reviewing the fact findings below and finding that that the judge below didn't apply the law correctly and that it can intervene on the grounds that the fact findings were perverse, then I don't see how you can just compartmentalise it in the way that you're seeking to do and say, well, we can just take this particular article that doesn't allow it to do this, but we can ignore all the rest of it that does.
Well, my lady, I'll have to actually come back to your ladyship's question if I may. It's not a point that has been raised.
I mean, the problem I have is that I have looked at all this, and when I look at it, I see things that might or might not quite readily fall within the kind of factual review that this court is allowed to do, as in the assicurazioni, for example.
Yes.
As compared to ones it's not. And some of the things that the Supreme Court seems to have said is, well, it's obviously wrong that he can have had no responsibility for this because he was there and should have known this, and this, all
yes.
no doubt findings below. So we're drawing a different conclusion from established facts. Now, it's impossible for us, really, absent massive amounts of expert evidence and getting into the case as if it were our own case, for us to say that is not permissible for the Spanish court. And, you know, I just wonder whether, you know, where this is all going. I mean, we've got some points of law here that are really quite important and difficult. I think we can all understand and accept that. If the case turns on this point, then, you know, speaking only for myself at the moment, I am very concerned at how we determine it. So I don't know what, maybe everybody wants to go away overnight and have a think about it, but I'm, you know, we're not, I was going to use we're not a kangaroo court. We don't just decide things on the hoof without proper argument and evidence and law. And I'm, for one, just simply not prepared to go into this thinking, well, I may get the wrong answer. You know, I mean, it's not the way we operate. And I know you're doing your job, and it's no criticism of you or your side, actually. But there does have to be a consideration as to whether this is the right way to pitch this before the Court of Appeal on day 6 and 7 of what we've been confronted with.
Yes, I follow that.
Yeah. Okay. Well, it's not a criticism, let alone a personal criticism, but it really is something for people to think about, because I feel jolly uncomfortable.
And as I've indicated, my lord, I fully understand your lordship's position.
Yeah. I mean, I'm not saying that affects the way I'll decide. If you say, no, you've got to get your nose into this and decide it for good or bad, well, we'll think about that. But I would like you to think about it before I'm forced to that.
Well, and I've already indicated, my lord, in a sense, the way in which the various different constituent parts of this appeal fit together.
And well, I understand how they fit together. That's the first thing I did in this case, was to work out how they fitted together. But your absolute embargo has just struck.
It has, and I was, as a result of that, I was going to say the witching hour has come, as far as I'm concerned, and that in those circumstances, I was going to sit down and invite the court to ask Professor Webb any questions that they wish to.
Yes, we will. I just wanted to comment that I noticed that the judge below in the provincial court is described as most illustrious president, which I do still love, but the Supreme Court justices are only their honours.
That's as it should be.
I'm sorry, but it's probably good to lift the mood a little. Professor Webb, yes.
My lord, my ladies, you've received a short supplementary note on the third ground relied on by the club, which is that the civil liability judgment arose out of a conviction in violation of Article 14.5 of the International Covenant on Civil and Political Rights, which codifies the customary human right not to be convicted on appeal without further review of conviction and sentence by a higher tribunal. And the club submission is that this forms part of English public policy.
Yes.
Just on my lord's recent concern about reading and judging another court's decision, and this is not the exact point you were discussing with Mr. Hancock, but relevant to this ground. As Mr. Hancock alluded to, the UN Human Rights Committee has looked at this very case, has looked at these very judgments in the provincial court and the Spanish Supreme Court.
Does it bind us?
No, it doesn't,
No.
but it is of persuasive value. And 16 legal experts appointed by the UN unanimously found that Spain had violated Article 14.5 of the Covenant.
And how long was that hearing?
I don't have that information before me, but it was striking that all 16 agreed, and then the concurring joint opinion was simply to be even more critical of Spain.
I mean, there are some remarkably strong feelings expressed in this case on both sides, really, which do surprise me. Normally when we get to the Court of Appeal, people sort of abandon some points as being not really, probably a bit too far for the Court of appeal, and they stick to quite discernible points of law by which the court can make a decision, applying its legal knowledge and experience. I'm slightly, let's put it very modestly, surprised by the extremity of the points being taken on both sides. It seems to be, extreme that the UNHRC reaches such a decision about the Spanish court. It's a bit like it would give me discomfort, so presumably it would give them discomfort. I mean, this is a foreign-friendly state in a democracy with, which we respect, and we used to be members of the same European Economic Community for quite a long time. But, there we are.
I think the issue in the Human Rights Committee was not looking at corruption or criticism in that way, but consistent violations of the right to appeal. And this is just...
But this is a consistent violation of fundamental rights.
Yes. Yes.
Fundamental rights.
That 174 states have signed up to.
174?
States have signed up to. Those are the
Yeah.
parties to the International Covenant.
Yes. Okay. Well, good.
So, my lord, my ladies, there are 4 points in the supplementary note, and I'm conscious of time. I wanted to just make a clarification on one of the points and briefly highlight 2 important cases, Freedom and Justice Party and the KU case, and then, or in addition, answer any questions that you may have on this particular submission. Now, the clarification is relevant to the 3rd point in the note,
Which paragraph?
It's paragraph 8 onwards of the note, that the customary international law rule in Article 14.5 of the International Covenant is not undermined by Article 2, Protocol 7 of the European Convention. And this comes down to the question of how do we identify a rule of customary international law. And you see in paragraph 9 the reference to the Freedom and Justice Party case, also in the Court of Appeal, and you don't need to turn it up, but it's in Authorities Volume C, tab 27. And that judgment relied on the work of the International Law Commission. The rapporteur happened to be our own Sir Michael Wood, former legal advisor, which clarified how you identify a rule of customary international law. And they said the relevant practice must be general, meaning it is sufficiently widespread and representative, as well as consistent. And then applying that in the case, the Court of Appeal found, even though there was some variation in practice on special missions immunity, that it did meet the criteria of a customary rule of international law. So you see that in paragraph 10, the breakdown of the state practice that they looked at, 36 states responding to a survey, 23 indicating that immunity was required for special missions, 5 saying it only may be, and 8 not expressing a view, and a large number of countries not being covered by the survey. And we can compare this, and this is paragraph 12 of the note, to the state practice on the right not to be convicted on appeal without proper review by a higher tribunal. And here's where I have a clarification to make to your lordship and your ladyships. It states there that the International Covenant has 173 states parties. It is actually 174. South Sudan has recently ratified the covenant. And in the next bullet point, it states that 9 states have entered a reservation to Article 14.5. That number is in fact 10. Germany has also entered a reservation back when it was the Federal Republic of Germany, and that reservation actually specifically refers to convictions on appeal. So with those modifications, the actual proportions don't differ, but I just wanted to be accurate before the court. So we have 174 states parties to this treaty. 10 have a reservation to Article 14.5, but only 6 of those states refer to their reservation being in relation to convictions on appeal. That's Austria, Belgium, Denmark, Luxembourg, Norway, and Germany. Spain did not make a reservation to Article 14.5. Now, when we turn to the Protocol number 7 to the European Convention, which in Article 2 permits the practice that we've seen in this case, that there is no further proper appeal after a conviction first made on appeal, there are 43 states parties to that protocol, but only 7 of them have entered a reservation under Article 14.5, and only 5 of those have actually made reservations in relation to convictions on appeal. That's Austria, Belgium, Denmark, Luxembourg, and Norway. So we see the vast majority of states, including the relevant states in this case, the UK and Spain, have accepted as a treaty obligation Article 14.5. There's also an important provision in Article 53 of the European Convention, which is that Article 2 in Protocol 7 cannot limit a more protective right that a state may have signed up to. In this case, Spain has ratified the ICCPR. It has no reservation to Article 14.5, and it has therefore been bound by it, and that provision takes priority. I then want to turn to my fourth submission, which is the KU, based on the KU case. And once we accept that Article 14.5 is a rule of customary international law, then we say that it is incorporated into English law and is part of English public policy. Now, the test for that is set out by Lord Mance. This is in paragraph 15 of the note, where he says that once customary international law is established, it can and should shape the common law, as long as it is consistent with domestic constitutional principles, statutory law, and common law rules. And there are 4 cases in which this potential conflict between a customary rule and a statute has arisen, and it's instructive how the courts have resolved them. So in KU, in the Supreme Court, the customary rule was the requirement for a state to investigate suspicious deaths. It was found that that was preempted by domestic legislation, in particular the 2005 Inquiries Act. So that customary rule was not incorporated. In the Horu case, also known as the Banku case, again in the Supreme Court, no, that was in the Court of Appeal, the customary rule was the right to resettlement as an aspect of self-determination, in that case of the Chagosians, and that was found to be preempted by the Biot Constitution Order 2004. So again, that customary rule was not incorporated. In Jones, the customary rule was the crime of aggression, and it was found that Parliament regarded that area, the creation of new offences, as reserved for itself, and therefore it was not incorporated. However, in the case most analogous to this one perhaps, in Freedom and Justice Party, the customary rule that was found there, despite the variation in practice, was a rule of special missions immunity from criminal jurisdiction, and the court found there was no legislative intention to reserve that area for itself, nor any statute going against it, and that rule was incorporated. 2 final points on this submission. Spain cites Section 3 of the Criminal Appeal Act as a provision of English law that allows the substitution of convictions on appeal against original convictions, from which the appeal is limited to points of law and subject to a requirement of leave. I'll just give you the reference to where Spain makes that argument. It's in Core Bundle, tab 19, footnote 53 of their skeleton. But this is not analogous to the procedure that is in issue in the Spanish courts. So Article 14.5 is concerned with providing a right of review of a conviction and sentence by a higher tribunal the first time that a conviction is made, even if that occurs in the highest court of appeal. By contrast, the Section 3 Criminal Appeals Act concerns the substitution of an alternative offence, and it's very strictly circumscribed, including that the new sentence cannot be more severe than the original sentence. And then the second and last point is that for completeness, and this hasn't been raised by the states, but the club notes that the case stated procedure in section 111 of the Magistrates Court Act 1980 is also not an example of a domestic statute contrary to Article 14.5. And it's not in the bundles, but just as an additional point, in the Kukurian and CPS case 2024-1, Weekly Law Reports 4070, the Divisional Court held that the defendant retains the right to appeal to the Crown Court both on facts and law under Section 108 of the Magistrates Court Act. So that is not an example of a conviction on appeal from which there's no proper further review. Unless I can be of further assistance.
Thank you very much. Thank you. Good. Well, we look set then to finish this tomorrow. Mr. Hancock, we've set you a little bit of homework. Hopefully you'll be able to help us in the morning.
Yes.
We'll sit at 10:30.
Thank you very much.
Court rise, please.